Hello, a very warm welcome to today's Scottish Golf Zoom panel. We are delighted to be joined by representatives from Harper Macleod LLP, Scotland's first recognised sports law specialist team. I'm Ian Evans, the Club Business Manager at Scottish Golf, and I'll be your host again today. On today's call, affiliated golf clubs will have the opportunity to hear from and pose questions to Andrew Hunter and Kelly Fraser, who provide expert insight on several topics and challenges facing clubs, including the hosting of general meetings during COVID-19, Incorporation, GDPR, and much more. We've received dozens of pre-submitted questions, so thank you for taking the time to send these in. But don't worry, if you didn't get a chance to submit a question in advance and you'd like to, then you'll be able to submit your question in the Q&A function. Just click on the button below, type in your question. Also, you may find that today's discussion prompts you to think of questions that relate to your situation, so please do submit them and I'll try to get to as many as I can. So without further ado, let's meet today's panel. First of all, I'd like to say we have Andrew Hunter, who's a partner at Harper Macleod. Andrew is a Chambers UK top-ranked leader in the field in licensing and also a Legal 500 recommended lawyer in licensing. Andrew is a Law Society of Scotland accredited specialist in liquor licensing law and a member of the Law Society Licensing Subcommittee. Andrew specialises in providing advice on licensing law, including alcohol, civic government and gaming licensing. Andrew also specialises in providing debt recovery and insolvency advice, including payment actions, property recovery, contract disputes, and non-monetary remedies such as interdict for trustees, financial institutions, and private clients. Andrew has a vast amount of legal experience in a sports setting, including golf in a personal capacity. Andrew was captain of the Williamwood Golf Club on the south side of Glasgow in 2014 and served on the committee for 3 years. Excuse me. He has been a member of Williamwood for 30 years and is also a country member at Moray Golf Club. Good afternoon, Andrew.
Good afternoon. Thanks for having me.
Thank you very much for coming. Also delighted to say we have Kelly Fraser, who is a senior associate at Harper Macleod. Kelly manages and is the principal contact for all referrals for the Sports Scotland Legal Expert Resource Helpline on behalf of Harper Macleod, working closely with Sports Scotland and many sports governing bodies. Kelly's principal areas of expertise are governance, regulatory and data use, and she regularly delivers training on governance and data protection matters, particularly in relation to preparations for the challenges introduced by the GDPR and legal structures to Sports Scotland and sports governing bodies. Kelly was a volunteer at the European Championships of 2018 and a member of Snow Sports Scotland's Governance Committee. She also acts as clerk to the Board of Scottish Swimming. Good afternoon, Kelly.
Hi there.
Thank you very much, Carl. A huge amount of experience there. So let's get right into it. So we have we received lots of questions in advance. They fell into a few different categories that we grouped together. So licensing, debt recovery, some general litigation, GDPR, Incorporation, which is a big ticket item for clubs, and also very currently the general meetings during COVID. So start off with licensing. So the first question is, have either of the two panelists been aware of premises who hold a private club license? If the local licensing boards have increased the number of occasional licenses a club can host for 2021?
So I think that will fall to me. Regrettably, no. And the principal reason for that is that, unfortunately, local licensing boards don't have a discretion. So the rules around the 56 days, which club managers will be familiar with, comes from a piece of primary legislation. So it would take the Scottish Government to change the rules in order to allow more days effectively. So whether or not the licensing board locally would wish to allow more days, they're not permitted to. It's a central government matter.
Okay. This is one I've had a lot in my time with Scottish Golf at different clubs, so I'm interested to hear the answer to this one. The question is, in the past, we've considered changing from a private club licence on our bar to a public one to bring in more people. What do the panel think are the main considerations, benefits and drawbacks of this?
So from a licensing point of view, as you may know, club licenses benefit from certain I suppose, exceptions to the general rules under the Licensing Scotland Act 2005. Those benefits, however, are generally at the outset of the licensing process. So, for example, were you to create a new club, you would benefit from avoiding rules about over-provision, too many licenses in an area, for example. Once the license is in place, the licensing or alcohol sale benefits of being a club over a normal trading premises are actually fairly minimal. You do have the exception of having to have a named premises license manager on the license, but in reality, most clubs will have a personal license holder, at least one of them, because that individual will need to be on hand to train staff and authorise sale of alcohol. So on a day-to-day basis, on an alcohol point of view, there's not much benefit in being a club premises versus a normal on-trade premises. Having said that, there are ancillary benefits that come with being a club premises, and those include permissions in relation to gaming and gambling. So a club has entitlements from the Gambling Commission, which are to allow you to bet at higher or play poker and games and such as that at higher limits, whereas if you like a commercial premises like a public house can do so, but at much lower limits. Machines, again, higher categories of machines are allowed into clubs, whereas public houses have automatic entitlements which are much lower. Changing over to if you like, a general premises license would allow you to have members of the public to the premises who weren't signed in by members, because you would be accepted from the general club rules. However, if you were going down that route, you need to be careful with your constitution, because club premises and constitutions will have not-for-profit clauses in them, membership, ownership by members, and changing over to a general premises license may change that. You also have to be taking some care around other cost factors. So, for example, a club premises will be protected by having its annual fee at the lowest category, I think £180. But once the premises were commercial, then you run the risk or potential risk of having higher rateable values, higher annual fees for licenses, which then equally can have a knock-on effect for annual fees to likes of Sky and so on if you're using that in your clubhouse. So it's not for everybody. It can draw certain benefits, including you would be removed from the occasional license restriction of the 56 days we talked about, or I talked about in the first question, but you would need to do your research in advance to make sure the cost-benefit analysis was in your favour.
Excellent, thank you very much. And there's many clubs that are serving more drinks outside with the COVID restrictions. Is there any difference in licensing for indoor and outdoor areas for clubs?
Yeah, very simply, outdoor areas are separately regulated as part of the license. So the indoor parts of the premises will simply be regulated by the normal hours that follow with the license. Outdoor areas will require, first of all, to be specifically identified in the layout plan, and likely required to be delineated, whether by the likes of canvas stands that you might see in the street if you're walking past a pub with a beer garden. And they're also likely to be restricted in terms of times of use in order to reduce ambient noise and upset neighbours and so on. So you tend to find that outdoor areas are restricted to about 10 o'clock at night, depending on where the location is. In terms of how they're served, they comes down to really local licensing board policy, whether that's by members of staff waiting those tables, or in the most cases, customers or members going into the clubhouse and taking the drinks out themselves. That's very much a local issue around licensing. But as long as the area is not on the street front, and you're not going to require any additional permissions other than the license itself. And the thing is just to watch around hours and upsetting the neighbours with noise when people are regaling their stories of holes in one.
By extension to that, we had one question about, if you have a license for selling alcohol in the club, does that by virtue of having it extend to the golf course for consumption of alcohol? What's the rules around?
So the only way in which the course itself would be included in the license is if the course itself was mapped out in the layout plan. It would be extremely unlikely to be included. And the simple reason for that is that alcohol capacity is based on the footprint of the layout plan. And if you included the course, you would likely then have an alcohol license with a capacity of about 150,000 people based on building standards, regulations about the size of the course. Probably more than that, actually, probably far, far more than that. and the club could never cope with the toilet provision that required to have that. So the most likelihood is that members will purchase off sale from the clubhouse and consume on the course, providing bylaws allow it, or alternatively they bring it on site themselves. But if the club is looking to offer a sale on the golf course for a captain's day or something of that nature, then I would suggest looking at occasional licensing to cover that particular event.
Okay, thank you very much. Moving on to debt recovery, I had a couple of questions, I'll take them together. One was the classic one: if suppliers don't pay up, what action would you suggest they take? And particularly, what if members? It's quite common that clubs will allow members to pay by direct debit to split up the payment, as many people would do for a product of that value. If a member stops paying, say in the winter months, for example, this is the example here, what would you advise they do when the amount they might get back is significantly less than what it would cost them?
Yeah, well, the depending on the, I suppose, if you take them separately of non-members and member debt. So in non-members, my view is always that depending on the nature of relationship you have with that debtor, you will dictate what you do. So if it's a one-off supply issue, then you would go at it as hard as you can to recover the money. If you're likely to have an ongoing relationship with a supplier, then you may take a more negotiated approach to try and resolve the dispute, because you might find that in due course you're in their position and you will look for the same, I suppose, leniency, for want of a better expression, from them at a later stage. It really depends on the individual relationship. Having said that, if you do have to go down the contentious route, simple procedure in Scotland, which is the debt recovery process for sums due under £5,000, has been revised in the last couple of years, and it's very simple for a club to deal with it itself. The forms are very straightforward, and the guidance notes on the Scottish Courts website are very straightforward, which would mean that it's a reasonably simple process, as the name suggests, to pursue your own debt recovery. From a member's point of view, I always have found, certainly in my time in committee, leaving aside my experience as a lawyer, that using the golf course as the carrot to beat the member with, or the stick to beat the member with, is always a good one, in the sense that withdrawing playing rights is clearly an incentive to pay. The other way they might look at it is if the concern is around the winter months in particular, you might, on a practical level, look at adjusting your payment dates so that people are paying for the winter at the start of their annual year of membership rather than at the end of it. That way, they're incentivized at least to pay during the winter months in order to get the benefit of the later months when the weather improves. Unless, of course, you're a member at Carnoustie and you can play all year round. But certainly at Williamwood, we're very much a 6-7 month season. But there's no reason not to pursue members for recovery of sums, unless, of course, there's perhaps non-legal reasons not for doing so.
Sure. And just a general question, of course, litigation is an area of speciality for you. Can you tell us about any issues and challenges that you see in golf clubs, litigation, and things the audience of club managers and officials should be aware of?
Well, I mean, I'm sure many of the club managers will not only look at themselves as a golf club, but also as a business. And on the basis that you are a business, you're not immune from all of the different types of dispute that can arise for any other type of business. And when I was looking at the questions in advance and I was preparing my notes for today, I took the opportunity of looking at the court session website to see judgments involving golf clubs. I found 71, and they ranged from land disputes, tax, petitions for judicial review against committee decisions, damages for trolley fires. There was a power caddy case, and of course the one that many club managers will be familiar with, the Fee and Gordon case, which resulted in putting up signs to tell that there was a sign ahead of you, in order to warn of danger. And I think that case probably changed the landscape of the way club managers look at their golf courses, certainly in the recent past. So simple advice would be that if something doesn't appear straightforward, to nip it in the bud and get advice early to avoid disputes. The other simple step I think any club can take, and indeed any business can take, is that where you are taking insurance, if you have the option of legal expenses cover within that insurance, then I would always recommend taking the option unless the expense is prohibitive, because it can be very beneficial in the event of disputes arising, or even just to have a name at the end of the phone. You obviously have ourselves through this process, but clearly any additional cover that might be available is always worthwhile having.
Excellent. Okay, moving on to GDPR. A few questions around that. I'm aware that's your area of expertise, Kelly. The question is, what if we state in our membership application criteria that names of all applicants will be posted on the notice board for 2 weeks, as has always been the case historically? Is this GDPR compliant?
So GDPR is everyone's favourite topic, I imagine. So the main thing around that is all around the right to be informed. So the main document around that is your privacy notice. So even though your membership application or criteria states that, I would also make sure that that is covered in your privacy notice, and your privacy notice should, either a copy or a link to the privacy notice should be provided in the membership application form as well. If you set out in the privacy notice that that's what's going to happen with the notice board, then that would be fine. And what you'll also need to do as part of drafting or revising your privacy notice is to make sure you've identified what lawful basis would apply. Now, the most likely lawful basis would be the legitimate interests lawful basis, which is where it's necessary to use someone's personal data either for the club's or for a third party's legitimate interests. So it's in the legitimate interest of the club to post names of applicants, either in order to comply with their constitution or for whatever purposes they have deemed necessary to publish that. Now, if you're relying on the legitimate interests lawful basis, what you do need to do, and what many clubs probably don't do at the moment, is what's known as a legitimate interests assessment. And it's a 3-part test, and it's effectively a little document that you do and you file away and you'll probably never look at ever again. But there is a template available on the ICO's website, and that's what I would recommend that clubs use. We have seen instances where individuals who have raised issues around how a club uses their personal data has asked for copies of those assessments. So whilst it's not, a club wouldn't need to give a copy of that assessment, I think making sure that they've got that on file for audit trail purposes in the event that a complaint went to the ICO would be really beneficial.
Okay, excellent. And the next question was, how long should we keep records such as meeting minutes and personal data of members who leave the club?
So retention of personal data is usually a favourite question, and the reason for that is the GDPR doesn't prescribe any set periods, so it's actually really unhelpful for clubs in deciding how long to hold on to personal data. The test is really, how long do you need it? So how long do you need to keep your minutes for? So certainly minutes should be kept for quite a long time, because they do demonstrate appropriate decision-making processes and compliance with the Constitution. So if you look at a company is under a statutory obligation to keep their minutes for around 10 years. So I would say that's a good starting point for clubs. Certainly you would look at reviewing your minutes after, say, that period of time, and then assess whether or not any decisions that were taken at those meetings are still live or are still relevant, and then that would give you a reason to retain that information for longer. In respect of members that leave clubs, again, it's up to you. What I would normally say is a good period is the period in which someone has a right to raise a court action. So that would be around 5 or 6 years. So I think it's 5 years, but what I would do is always keep it for 6 years. And then the trigger date would be when the member leaves the club. And then what you would do is you would look at the information you hold on that member after 6 years and decide whether or not to retain it. Now, there may be certain information that is kept. For example, if you have boards with winners or past captains on it, then obviously if that member was a past captain, their name will still be on that. But in terms of other information, like payment information, if you hold membership records, name and address, contact details, if they're no longer a member and they no longer engage with your club, then I would say after about 5 or 6 years, you should look at deleting that information.
Excellent. Are we within our rights to insist, are we within our rights to insist members allow us to use their data for certain things to do with providing membership, such as being contacted by other members for matches, or being sent club promotional things such as social events? Can we insist our members opt in to some things around the use of their data?
So this comes back to lawful processing, and again, every different use of personal data needs to have a lawful basis. So it's not an insistence as such, but clubs can decide that it is in either the club's or third parties' legitimate interests for members to be contacted by other members to arrange matches. Then as long as that's covered in your privacy notice and you've told members that, then that would be lawful under the GDPR, and also if you've done your legitimate interests assessment, as I referred to previously. In terms of club promotional materials, there's two ways to do that. You could again use the legitimate interests lawful basis, and all you need to do is make sure you give members an opt-out to that, so they always have a right to either unsubscribe if it's emails or opt out to receiving any communications. Or if you wanted to go down the consent route, you could ask for consent and ask members to opt in. But if you do use consent, then there are additional kind of steps that you need to take. Make sure your consent form complies. So in the template privacy notices that we did, which are available on our hub that we have, we did them quite a few years ago now, but they should still be relevant. We have got wording in there which talks about promotional communications falling within the legitimate interests lawful basis.
Excellent. Yeah, on that, the resources that are hosted, they're linked on the Scottish Golf website and also the hub as well. So I'd encourage clubs that haven't used those to go there. There'll be a great resource that came out. Just a last general question on that. Are there any areas around GDPR that in your dealings with clubs you've seen that maybe clubs aren't quite doing well? Are there any consistent areas you think they should try and tighten up on?
So privacy notices are still a key document, and what I see across golf clubs, other clubs, and all our clients generally is they put a privacy notice in place for the GDPR coming into force in 2018 and haven't looked at it since. So keeping your privacy notice up to date and ensuring it covers everything you do, I think, is a key issue and a key thing that clubs fall foul with. The legitimate interests assessment is also another one. I suspect that many clubs do not do that, so it's just to make sure that that is done.
Excellent, thank you. I'd like to move on now to incorporation. I know this is a really big ticket item for many clubs. There are a number of very large clubs in Scotland who remain unincorporated, and I know clubs have looked at it. So on that, the first question is, our club has been unincorporated for many years, but some committee members have said we should consider it. What are the main benefits of incorporation?
So the main benefit of incorporation is a limited liability. So what that does is that means that if a club was incorporated, the club itself would have separate legal personality from its committee members and its members. So that means that the club would be able to enter into contracts and buy property in the name of the club rather than in the name of individuals. The main issue is if a club owns property and is unincorporated, what it needs to do is the title to the property needs to be in the name of certain individuals, so either the committee members and who were committee members at the time or specific members. And the difficulty is that if those members leave the club or if the committee members stand down, you do need to be updating your property title, and that can have legal and registration costs every time you need to do that. So if your club was incorporated and you owned property in the name of the club, there's no need to change the title every time people step down from the committee, because it would be in the name of the club separately. It also means, limited liability also means that if someone wanted to raise a legal action against the club, at the moment, and I know this is a topic that we'll come on to discuss in a bit more detail, and that action at the moment would probably be raised against certain individual members, whereas if the club was incorporated, the legal action would be raised against the club itself. And limited liability means that the members who join the club, so say you had a company limited by guarantee, the members are usually only liable for a nominal sum of around £1, whereas in an unincorporated structure, that liability potentially could be larger if any action was successful.
Sure, that brings us next to the next question. So who is liable if something goes wrong at an unincorporated club? Is it the members or is it the elected committee? And is there any historical examples of this being tested in court for golf clubs?
So it depends on when a decision was taken. So if a decision was taken by committee members at a committee meeting and that decision resulted in a loss or an issue, then arguably the committee members would be liable. However, if a decision was taken at a general meeting and that decision resulted in a loss or liability, then there is an argument to say that the entire membership could potentially be liable as well. There have been some cases around this. One case in particular was in 2016, where there was a golfer who fell down a loose manhole cover, and he tried to raise an action, or he did raise an action for damages against the committee members. So he sought to argue that because the committee members had taken responsibility for health and safety, that they owed him a duty as a care as a member. But in that decision, the court actually felt that this amounted to suing yourself. So in that case, it wasn't successful, but it was primarily because the pursuer in that case failed to evidence the duty of care. Now, in that case, because it was a member suing yourself because he was a member of the club that he was suing, and the club was unincorporated. So there's still an element of doubt around if you have someone who's not a member who suffered a personal injury action. And I don't know, Andy, if you've got anything to add to that. I know you've looked at some other cases.
Well, yeah, I mean, there's the Fee and Gordon case, which I touched on earlier on, which is the one where I believe he was a visitor, sued both the individual who hit an errant golf shot and also sued Nidri Golf Club. And then there was a share of liability on a 70-30 basis. And that under kind of general principles of duties of care under the neighbourhood principles, but also owners of land, you have occupiers liability. So there is always a risk of third-party injuries where you're going to have a situation where the person pursuing the club for damages is not a member and therefore doesn't fall within that concern of effectively suing yourself.
Yep.
Andrew, I'm curious on a casual guard here, but you're someone who has been a captain of a golf club and a lawyer. And I just wonder, it's very prevalent for golf clubs not to be incorporated. Do you have any insight into why that might be? And would you encourage clubs to look at it, or what's your...
Well, I suppose being a partner in an LLP as opposed to a partner in a unlimited partnership helps me sleep at night, because I'm not saying, to draw the analogy, I'm not constantly worrying about what my partners are doing. Well, I am worried about what my partners are doing, but joking aside, I'm not worried about the possibility of something happening to the firm that could affect me significantly on a personal basis. I suppose that as a member of a club, I think there's probably maybe two reasons why incorporation hasn't really taken off. First of all is general fear of the unknown and general fear of the costs of doing it. Speaking as a golfer rather than a lawyer, I know that up until very recently, when membership, certainly at my club, has taken a move in the right direction because there's far less nomadic golfers about as a result of the coronavirus, most clubs were very conscious about how money was spent because of the increase in nomadic golfers and the decrease in membership generally, and the worry about spending money. But I also think there is probably an element of this is how we've done it always, so this is how we'll continue to do it. And unfortunately, I think it might take something really a really adverse outcome for a club where members are adversely affected, and to see a personal hit in the pocket to really perhaps cause a jump. The other side of it, of course, is that where a lot of clubs are selling land, there is the possibility of a direct knock-on effect to the members, and perhaps a concern that that if you become a shareholder in the club rather than a direct owner, there might be maybe less of a loophole. I really don't know. I know my own club is considering it, but beyond a general consideration, I don't think it's moved much further forward.
And on that, I mean, would that, if a club was looking at doing it, is that some type of professional advice that your company would give them, and what kind of steps would a club need to take if they were, they're not incorporated, but thinking about it, what's the first steps they should look at taking?
I think first steps would very much getting the membership to understand what it means for them. And one of the things that my own club did very well was that when they were simply putting the feelers out to the members about not so much becoming incorporated, but simply getting the membership to agree that we can even look at it, was to explain in very basic terms, right, on a day-to-day basis, this may mean X for you, or in reality, probably no real change. And I suppose change is always the fear. Most golfers just want to turn up and play, and they don't want to have to worry about the possibility of liability. And I don't know what will happen for us going forward, but I certainly think getting the membership to understand what it means for them is the key thing to get advice for, because ultimately, unless your constitution is different from the one I'm subject to, you will have to get the general membership to vote in favour of it. And
absolutely,
the learning curve is always the hardest one to overcome, I think.
Excellent, thanks so much. Just conscious of time, I'd like to move on to the last topic, which is a very topical one, which is general meetings in COVID, and a number of questions on this. So first question, our AGM is not till January. What sort of steps should we be starting to put in place for proxy voting and potential virtual AGMs?
So if you wanted to allow for proxy voting or a virtual AGM in January, you need to check your constitution first to see if this is provided for. So the assumption is that this is not provided for in the constitution that has generated, for the club that's generated this question. So the difficulty you have is if you need to amend your constitution to provide for proxy voting or virtual AGMs, that decision needs to be taken by the membership, which would probably require a meeting. So I think just to come on to a couple of the other questions, if you don't mind, Ian, just because a lot of these issues are kind of interlinked. So many club constitutions will either be silent on whether or not virtual general meetings are allowed, or they'll say that it needs to be at a venue, at a clubhouse, or in person. Now, because most clubs, as we've discussed, are unincorporated, they are solely governed by their constitution. And this means that if their constitution doesn't say something or doesn't allow for something, to do that would technically be invalid under the constitution. Now, there are wider concerns, and we're all in this very strange circumstance. So what I did was I have prepared a briefing note specifically on this issue, which is available on our club's hub, and I would suggest that clubs do read this. So effectively, if your constitution is silent or doesn't provide for meetings, the two options I think are either to postpone your general meeting until the situation is clearer and you're able to hold it in person, and what you would need to do is just send a notification out to the members. Now, the difficulty is that your constitution will unlikely allow for the postponement of the meeting, and what you would do is at the meeting when it is convened, you would just seek the members' retrospective approval to that postponement. The other option would be to proceed to convene your meeting virtually. Now, if you're going to do it virtually and you're technically not allowed to do that under your constitution, what I would suggest is you send a notification out to your members to say, our constitution doesn't provide for this. However, because of the current circumstances, we are proposing to go ahead with our general meeting virtually. And then you would invite the members to raise any objections by a certain date. Now, in the hope that no members raise the objections, what you would then do is send out your notices to convene your meeting virtually, and then just hold that meeting. And then next year, say you have your AGM next year in person, or you have another general meeting at your next general meeting in person, what you would do is you would pass a resolution at that meeting to seek the members' retrospective approval to the convening of that meeting virtually. If you did receive any objections, then hopefully that would be received early enough to engage with those members, and that's why I say ask for objections before you send the notice, so you don't have to cancel the meeting after sending the notice. And hopefully it would be a case of explaining to the members why you feel that it's best to go ahead virtually and why it can't be held in person. But I would hope that everyone is in an understanding of why the meeting would have to go ahead virtually instead of being postponed.
Excellent. I think you've pretty much covered off all the questions that came in on that. And I just reiterate, Harper Macleod have created advice notes for incorporated and, importantly, unincorporated clubs, and address all the questions there and go in a little more detail about what Kelly's very kindly just described there. So we will link to those in the link that goes out after the webinar, with the recording and the relevant documentation. So I'm conscious we've run a little bit over, but thank you very much. So ladies and gentlemen, this brings to a close today's Zoom panel call. We we would like once again to thank Andrew and Kelly from Harper Macleod for joining us today for their valuable insight and expertise, which no doubt will have been extremely valuable to all our delegates on today's call. Don't forget, if you'd like to catch up on any of our previous webinars, you can watch them all on our website at scottishgolf.org. Thank you again for tuning in. Stay safe and a very good day to you. Thank you very much, Andrew and Kelly again. Goodbye, everyone.
Thank you. Cheers, all the best.
Cheers.